first topic that, obviously why I'm here is how not to get sued, why you don't want to get sued. And so there should be some analysis that we all do as to evaluating our situation, evaluating our own practice, what we do, and evaluating issues that come to us. And a really good lawyer is going to be the one that is able to avoid the lawsuit that comes from that. But is that really something that you're going to get thanked for? And I think of this, 66 million years ago, last Tuesday, there was an asteroid the size of a city, and it landed in the Gulf of Mexico, and it destroyed all life on Earth. We still look for those asteroids. And a couple of months ago, there was a near-Earth object that came by, and it was reported in the news. And do you know what people said? Cool story, bro. Now, that's what is going to happen to you when you avoid a lawsuit, because there's really no known quantity or way to evaluate that other than thanks, because you don't know what it was. But I will tell you that we do need to avoid getting sued. We do need to evaluate. We do need to adjust the way that we perform and do our jobs to avoid getting sued. So this one I liked because it said successful pretrial practice, and that's what we're looking for. Why would we want to avoid litigation? InfoWars probably should have looked at this a little closer. But the situation that I find most frequently, and particularly in instances where there is insufficient or no insurance, which is seems to be my current practice, is concern, and it's worry, and it's vexation for the people that you are actually working with on a day-to-day basis in the city. Great example, 30B6 depositions seem to be all the rage these days, and the amount of time spent preparing, the amount of time spent in deposition is all time spent that is, first of all, it's obviously time consuming, it's obviously annoying and vexatious, it's worrisome, and it prevents the city from doing what the city needs to do and focuses on matters that are clearly not useful for city functions. The number one reason for litigation is communication, whether it is lack of communication or communication done poorly. I want to think in terms of, obviously I stole the slide, but when I saw this, it made me more aware of instances where each of these points has come to pass that has created a problem that resulted in litigation. Frequently, we have people that are our least trained and our least educated and perhaps our newest employees, and they are the ones that are dealing initially with the face-to-face public. Whether you think of someone in a water department or a city clerk's office, where you have the least trained, the newest person that is actually having to interact with the public. And so what I would encourage us to do is to make certain that these employees are aware that it's not just what they say, it's how they say it, and it's how they present themselves. I think of an instance recently with an employee at an area city, and she was terrible about coming to the front desk of the water department with earbuds in, and was actually actively listening to a podcast while she was trying to do business. Now, clearly, communication is not going to be her strong suit. Moreover, we did get complaints about this particular employee and the fact that they weren't paying attention, and obviously you're going to make mistakes when you do that. So I think in terms of the entire range of communication, so not just how you talk, but how you present yourself, and more importantly, how you listen. For us as attorneys, communication is our stock in trade. We need to be able to communicate directly with people. We need to be able to communicate with patrons of the city, with customers, and we always can do better. I think in terms of each time that I have seen a lawsuit, there is generally some moment that a communication, whether it was something we could have said, or whether it's something that we could have heard, or something we could have better reacted to that would have avoided the lawsuit. Anytime that you communicate, you are speaking on behalf of the city. And I think in terms of, my wife has a sign on her desk that says you can be gracious, you can be pretty, you can be cute, but whatever you do, be gracious. And I think that that is a good standard for us all to comply with, because in our business, there's a lot going on, and there's a lot going on all the time. And it is very difficult to slow your mind down, or for me to slow my speech down now, and communicate with people in a way that they know that they're being heard and that their concerns are being addressed by you or by someone at the city. I don't often run into this anymore, but certainly there are instances where I've had employees for cities that have gotten into personal attacks. We see that pretty frequently on social media, unfortunately, and we want to make certain that we can express to everyone at the city that we're not going to make those types of comments, that we're going to try to make sure that we address matters directly, and that we do so in a professional manner. I like the idea of communications in writing, and there's a number of reasons for that. First of all, anytime that I have seen an instance where there was not a communication in writing, it is rife with possibilities for misunderstanding. It is rife with possibilities that your expectations or the customer's expectations or a contractor's are not going to be accurately recorded, or there's some misunderstanding. I think that it is best always to do that. I know that we don't always have time to do so, but I will tell you that in almost every instance where I personally have violated my own rule, that it generally goes south. I think recently, in terms of a situation where I was representing a political subdivision, we'll keep this really vague, and there was a request from a patron, and the patron quickly became threatening. By God, we're going to do this by Friday or you'll see me in court. We did not apparently communicate well with that particular patron. And as a result of that, the matter escalated from what should have been a simple administrative appeal to a matter that resulted in a full-day hearing. I think ultimately my client was correct, but it doesn't really matter, because I think that at the end of the day, it would have been more efficient and effective if there had been better communications. There were opportunities, we just did not take them. And so I think in terms of anyone that is dealing with the public, you can be cryptic, you can be clever, you can be busy and not want to actually address people. But at the end of the day, we have a public service to do, and if there are, for instance, appeal rights, or if there's specific administrative remedies that need to be followed, it ultimately benefits us to provide that information in a useful and timely manner, even if it does take a little bit of our time away. I would also suggest that when you are communicating in writing, that you make sure that you've chosen the correct form. So I think in terms of a legal assistant that I had a number of years ago who could write the most scathing emails ever, Sean's laughing, and I don't think she meant it. It's just that she had a point to make, and she was going to make it whether you wanted to hear it or not. And there was a source of an awful lot of interoffice conflict. And people, you get this email and you're like, I can't believe they would say that to me. Well, the same works for an email that you send out to the public. So before you send an email, make sure, first of all, that it is written in a dispassionate way. Make sure that it is written efficiently. For me, because I'm a stickler about this, always proofread them, and never send a message when you're mad. That will be the one that bounces back on you for sure. Also, if you are going to communicate in writing, whether that's by a text to someone out in the field, whether that's by email to a customer, patron, citizen, make sure that that's the appropriate way to do it. Frequently, email is not the correct way to do it because it lacks context, and as I said, it can frequently be misinterpreted as being rude. Also, I would point out something that I've learned over time is to pick your battles. If you have someone that is going to be just a constant letter fighter for you, perhaps you're better off meeting with them. Perhaps you're bringing them in, having a conversation with them, and trying to clear the air. Always try to de-escalate. That's the golden rule for that. We live in a document-intensive age, and I will tell you that frequently we don't do it enough, oddly. I think in terms of instances where there has been a favor, you do someone a solid, they call in, you're busy, but hey, I'll take care of this for you. Unfortunately, in my experience, a solid is never deemed a solid because it was a solid only to you. What the customer, the employee, whomever you're dealing with had was a need, and that need doesn't change based upon your perception of how you did it for them. So in instances like that, what I have found is that there is generally a lack of documentation because you just did it as a favor, and those are the ones that typically come back and bite you. Second example. I had a client that was doing some repair work on an older home, trying to get some service to the house, and it was a piece of junk. I'm just not gonna lie to you. And we advised the woman that by putting the service through the stem wall, it could cause some damage. Oh, we're fine, Don't worry, I just really need the service through the stem wall. If you can take care of that for me. So we did. But we did tell her that, we don't know what could happen. It's a 100-year-old house. It wasn't a good house to begin with. Well, we got the hole through the wall. Everything was fine. We thought overnight, it collapsed. That was bad. And because that happened in the first wave of the COVIDs, we ended up going to trial in that one 5 times. The plaintiff had COVID, the witness had COVID, the judge had COVID. It was incredibly expensive over what was a matter that we had already advised. So a simple disclaimer like, hey, I understand that what you're doing could cause damage to me. A simple documentation of that, which they had their paperwork in the field. I don't know why they didn't do it, but that would have avoided me going to trial 5 times on the same case. And I could tell you at this moment, I could still do that trial without notes because I prepped enough for it. Make sure that you document personnel files. All of this obviously becomes evidence at a later date. If you do not do these things, you will not have them to use in your behalf. So make sure that the people in your departments, if they're having specific personnel discussions, make sure that they're documenting all of these employee contacts. We don't want to end up in a situation where the first time the employee is aware that you've messed up 15 times is at the termination. As municipal attorneys, always a better idea to try to document any agreements that you have made with outside sources. That is a matter that anytime you've done that, you will find that expectations, the boundaries of what was to be done, the time period in which it was going to be done, the overall costs, those types of things should be managed in advance and in writing. Make sure any change orders, anything of that nature are also done in writing just to make sure our expectations are all the same. I stole this slide too. But make certain that when you are reviewing your policies, you should, number one, you should do it, and it should be done on a regular basis. There's nothing like answering discovery in a civil rights case or an employment matter, only to find that the city actually hadn't looked at these policies in 20 years, 30 years. I've had some of them recently that I saw that were actually typed in Courier, single-spaced, that was done maybe back in the early 90s. My sense was that those hadn't been looked at in some time. Make certain that you at least go through each department's policies, your overall policies, make certain that they're up to date and something that you can rely upon, that you wouldn't be ashamed of presenting in front of a jury. Specifically, I think police policies and procedures, those are constantly evolving, and make certain that those are in compliance with our current standards. There are some excellent resources out there for you to compare. I'm presently reviewing a department's policies, and fortunately, there is a tremendous amount of material out there to make sure that we're up to date, and there are peer-reviewed materials that you can rely upon. I also think in terms of a matter where I had a client who had a policy for an administrative appeal, and we actually got tested on it, which is the bottom left-hand corner there, and come to find out it was illusory. It didn't really work. If you went through this process, it wouldn't accomplish anything. So under those circumstances, we're having to redo that policy. But I would encourage you to look at your policies that you do have and test them. Do these policies actually work? Do they accomplish what you want to have done? Or will you end up in a situation where for the first time you realize, you know what, that policy actually doesn't accomplish anything? So that would be a good way to avoid litigation, because again, we ended up in a lawsuit on that as well. This is an easy one. Untrained employees are a massive font of problems. And I would tell you that the effective onboarding is going to be a situation where you need to be able to tell your employees as they come on what your expectations are. And I've had a number of situations. I'll give you a couple of examples. We had an employee who, for whatever reason, had a very good explanation for why, as a recent hire rather, she should be able to take off on a trip. And to do so was in violation of the personnel manual. However, because we were good people and it seemed like, we needed some more people to work for us, and it had been difficult to hire during that time, we went ahead and allowed that to take place, which the employee decided, hey, I can take off anytime because those policies really don't apply to me. And then she did. In the first 4 months, she burned up all of vacation time, which I don't believe was even earned or accrued up to that point, and then began to burn some additional time off just trying to abuse the policy. So probably should have done a better job documenting each instance with that employee that there was an exception, that was an exception only and no more, but we didn't do that just because we were good people. We're nice people, just assuming that everyone would come to work when they were supposed to, and that's not a good bet anymore. Another one was an instance on showing up to work on time. My favorite example of that was someone that we had that was supposed to be there every morning at 8 o'clock to open the office and wasn't. And how to address that problem was simply to meet with the employee and to advise them that if they weren't there at 8 o'clock, they were in their car at 8 o'clock or in the elevator or walking up the sidewalk, that would be a great day to go to the lake or to look for an opportunity to fill out your resume for someone else, because at 8 o'clock, you weren't going to be there anymore. And, it actually worked. One day she was driving to work and realized it was 8 o'clock, and so we didn't have a receptionist that morning. But the purpose of that was to make certain that we were expressing and clarifying that there was a problem and that it wasn't working well. If we don't specifically address these issues, those are kind of silly examples, but where I have seen this become a problem is where there is a discrete minority, where there is some discriminatory facet that they can claim, and then what you have is a problem because we have allowed these other problems to exist. We've allowed them to get around our rules, and then anything that we do to try to enforce, in my experience, is all deemed to be a Title VII claim. So effectively treating everyone with the same yardstick is the best idea on that. Routine follow-up, it only happens during Title VII claims, but it's at that time that you really wish you had just done some periodic Title VII training with your employees. Doesn't take much. My inbox gets inundated with examples of people that didn't do that. So not very difficult to do that. And then if we do have some record that we are continually training our employees on Title VII issues, we can hopefully minimize our litigation exposure in those ways. I will tell you that being proactive is a difficult task. I know that we all have a lot to do, and being proactive can make you feel like a nosy ninny as you're going around and kind of snooping in other people's business. But the reality is that we do have to be proactive, and we do have to anticipate problems that are coming, whether it's new case law that changes a liability issue, whether it is a new situation, some new threat, or some new situation that has arisen in our community. You need to be on top of it. You need to be ahead of it, because I can tell you from a litigation perspective, if you are being reactive to this, you're on your heels and you're not fighting, you're just losing. So if you stay ahead of the game, you can minimize your litigation in that respect. But this is something that you will have to figure on your own. What are the issues that are coming up? Are you hearing issues from a specific department? Are there problems that are from citizen groups? Are there issues that have arisen within your own department? Those are matters that you need to look into. And the faster that you get on top of that, the faster that you're able to respond, then you'll be able to minimize whatever damage is actually slowly eroding in your presence. I think about a situation recently that my son, who's entered the professional world, had a friend of his that got a really good job. And it's with one of the AmLaw top 20 law firms. And their onboarding process for their associates is, if I used the word draconian, you would think I'm exaggerating, but I'm not. But it is the warnings that they provide to baby lawyers who are billing out at $850 an hour, which we are all in the wrong place, I'm going to tell you. But some of the things that they told their employees, I think apply to us as well. And I think that we need to kind of keep this in mind as we do our jobs as municipal attorneys. And one of the things was that we are online 24/7. So just be aware of that if there is a problem that comes up for the city, you need to be able to address that. You need to be aware and available to take on whatever challenge or issue that is being addressed. It's unfortunate, no one wants to do it, but it's our job. It's what we do. Their next rule was that you are expected to do everything perfectly and delivered yesterday, which is obviously the expectation of our clients. But the point here is that everything that we do, we need to do our very best, and we need to be prompt. And we all have personal issues, but at the end of the day, the good of the service is us doing our jobs promptly and efficiently and as best we can. The one that I thought was most interesting, though, was their rule that you take ownership of everything you do. And this included, once you touch a document or enter the work stream, you own every mistake in it, fair or not. And I got to thinking about that, and that's not fair, but that's absolutely true. Once you get engaged in a situation with the city, once you get engaged in litigation, you're part of it. And you can't just be a little bit pregnant. You are a part of the entire situation. And I thought that is a really good thing to teach, first of all, young lawyers, but secondly, to remind ourselves that we have to take responsibility for everything that comes across our desk and to be aware of what we're doing. So being proactive helps us to take responsibility, and in that regard, can help us to avoid problems. Okay, the first one. That is a problem. So anytime that we are dealing with difficult people, And whether you are the size of Bokoshi or the size of Lawton or Oklahoma City, there are going to be people that we come into contact with that are absolutely freaking nuts and that have problems and that want you to fix their problem yesterday. And they are not happy. And they generally will have been through a couple of people before it lands on your desk, and those people didn't fix their problems. In fact, those people may have made the problem worse. So be aware that those are going to happen, and make certain that you have some plan in mind when you encounter these people. It is going to happen. I think of a situation I have right now with a pro se plaintiff, unfortunately, and he has absolutely failed to understand and appreciate what he's doing. I'm smiling, Amber. And he has completely misunderstood the purpose of municipal court. He has completely misunderstood the concepts of condemnation, and he's completely misunderstood what the purpose of law enforcement is. But that did not stop him from filing a case in federal court. Moreover, it did not stop him, frankly, from going to the federal courthouse and bugging them, which was kind of fun because it wasn't me. Dealing with these people, though, I would admonish you for a few simple things. Number one, they are easy to aggravate, and enhancing and escalating the hostilities is not going to be a good idea. Number two, anytime you deal with these people, make certain that you're not alone. Make sure to have a witness. Make sure you have someone nearby. Whatever they're going to say, whatever they're going to do, you don't want to be alone with them on a one-on-one basis. Absolutely, positively document the meeting. In fact, I would record it. You just need to have that record. You don't want someone making wild accusations about you. We had another case recently, another pro se, and we were fortunate that there was a body cam because the incident that he addressed in his complaint with respect to an encounter with a police officer, you looked at the body cam and you looked at the complaint, and you're like, these are completely different events. They didn't happen to the same people. But we had that recording, which was super helpful. So if you are going to encounter these people in a pre-suit manner, I would suggest recording it, making sure that you've got some record to protect yourself. I like this next one, which is simply to remove yourself from the situation. If you sense yourself getting emotionally involved with this, don't escalate the situation. You can always take 5. You can step out, take a call, take another day. And then the last one that I would look at is, in addition to assume that you're also being recorded, is that I have also served in the past as a corporate assistant in terminating people. And I don't know if anyone ever saw the old Cheers episode where Norm was hired as the corporate hatchet man. No? Okay. Anyway, I always assumed that those were not going to be safe for me as a human being. And I have always had protection there for me because despite my intimidating demeanor and size, I'm not going to fight nobody. So I did have someone there, whether that was just a wingman or frequently retired highway patrol. So make sure that you don't get yourself in a situation where you're going to get hurt. There's too much craziness out there today. Way too daggone many people toting guns around. Way too many people that are flying off the handle. Don't put yourself in a situation where you could get hurt. The next one is to hire a competent outside counsel. I mean, I don't know how that guy's picture got up there, but you obviously have limitations as a municipal attorney, and hiring outside counsel, there's some people here that have actually even retained me from time to time, is a great idea. And to get that done early, when you sense that there's going to be a conflict among your employees in a litigation, whether you have a situation, as Beth Ann mentioned earlier, like you just don't know, like I haven't encountered that, how do I fix this problem? It's best to reach out to somebody, whether it's a fellow city attorney or someone that you just know. And in any event, it helps you to get a second set of eyes on a problem, and having that can frequently give you a different path, maybe something you hadn't considered, maybe a resolution to a problem before it ends up before a judge. This is big. Wow, I did not imagine that this was ever going to be such a big part of my practice. But there are literally plaintiffs' firms in Oklahoma right now who will file a spoliation motion on every dadgum case. Matt's shaking his head. It's every stinking time. And unfortunately, it's doggone expensive. Fighting spoliation motions is it is incredibly time-consuming, frustrating, and frequently can be prevented. So let's start with electronic files. Make sure that you have, and I know that these things are not cheap, but make sure that you have a backup system so that your 20-year-old computer that you have in the dispatch office doesn't suddenly crash with all the information that you needed for this specific call. Make sure that you have done some backup, that if it's off-site, that's awesome, if you've got it to a cloud, but make sure that you've made those arrangements in advance. I had a situation where we sort of kind of copied over things because we needed hard drive space, and those tended to be obviously the things that we needed in the litigation, which raised an issue about whether we had spoliated those documents. So the IT department is absolutely critical for the city right now. Make sure that your computer files are protected. Now, for those from Tulsa, I didn't hear anyone from Ponca City, but there was Ponca City. Okay, so you remember then when the Ponca City Public Schools had that threat that their files were being hijacked. Yeah, those guys were serious. They really did. They deleted the school's entire files. I don't think we thought they were, but they did. And so I've been in litigation for them recently, and it was a little uncomfortable because we didn't have anything because it was all gone. The city of Tulsa, I've had situations with one of the assistant city attorneys where claims had to be discharged because the files had been subject to a breach and were lost. I would point out also some exhibits that I had got lost in that as well. Yes, sir. Okay, so the way that plays itself out is if we have allowed relevant evidence that was, for instance, on a server, or documentary evidence that was subject to a purge, we've allowed relevant evidence to a lawsuit to be lost at the time that we knew that it would be subject to litigation, then allowing that to be lost is subject to spoliation. Spoliation can then be subject to sanctions. The sanctions can include monetary damages, which I saw recently, very recently, or worse, an adverse inference instruction. So basically you give the plaintiff's counsel a blank jury instruction that says this is what that would have said. Not terribly helpful. And they're very difficult to overcome. And generally because where I've been seeing it most is in electronic files, then we have to have someone go in and rebuild our computer files, or find where that was, or figure out where it was on the hard drive, or explain why that hard drive happened to conveniently crash right when that information was needed. Likewise, people that are carrying cell phones around, like everyone here is, and if you've been texting about, for instance, let's say that you have a police event, and they're texting about an arrest that went bad, and then those texts get deleted because they didn't want anybody to see them, that's spoliation. And there are sanctions that apply to that, and they're rather severe. Which, let's just jump to the last point there, which is anytime that you get notice of pending litigation, it would be your best practice to put a litigation hold on everything. Go find the cell phones, go find the iPads, the laptops, the emails, the text messages, the photos, and just about as frequently where someone has put it on Twitter. Some blast that they said improvidently, and then it gets taken down. Go capture that stuff. Go ask the question, did you post that on Facebook? Are you serious? You posted that on Facebook too? And then took it down. So you need to ask those questions because you need to salvage and save all of that. And at least you have it. Now, once litigation gets started, of course, there's the issue of, is that even relevant? Is it discoverable? Is that going to make it into court? But if you don't have it, you are not in a safe zone. I don't know how many times I've heard of some of our older municipal buildings that flooded, and we had, an entire, Sean, we had an entire box or boxes of, very useful information that just is gone. So protect your files, protect them. Where are we storing our things? Is it safe? Is that, yes, ma'am?
I'm the head of litigation in the city of Tulsa, and we have gotten a lot of issues with, we send a retention letter when it comes to like threat and lawsuit, but we're seeing them more in the tort claim phase. Attorneys send a tort claim and then request retention. Do you have a recommendation on whether the tort claim phase should start the gathering all the document retention process?
Yes, I would say yes. I mean, that's your notice of a claim. I think it would be difficult later in court to say that, well, we didn't know there was a claim, or we didn't know to go gather that information where there is a notice of tort claim that's been provided. I would say yes, because there's no harm in doing that also. I mean, it's a nuisance, obviously, I know, but there's no downside to having that information, and then you can always release it. Then the last thing is, do you know how your email's backed up? I mean, does anyone know how you can collect it? A few? Yeah, that's very difficult to dig through. I would encourage you to go ask your IT people, where's our email? If for instance, we had a subpoena for emails from certain accounts for a certain period of time that would go 2 or 3 years back, can we do that? Could you? Has that been lost? Those are questions you need to know the answers to before you get it asked at a really bad time. This isn't really in my bailiwick, but I know that municipalities have a lot of situations where we do actual manual labor. I try to avoid that at all costs personally, but we do have situations where there's heavy equipment, where there's people pushing shovels and brooms. And do you have the appropriate safety measures in place to avoid and minimize injuries and accidents, to reduce the hazards that are there? Does your department head do routine training on how to avoid back injuries, how to do their job safely, to put up safety cones, wear the appropriate vests and blazes? Make sure that those are there. That's an easy one to go investigate. Legal risks. If you know, for instance, that you have a department that just doesn't do that job very well, and you have a particularly onerous client, customer, patron that has a difficult job, you may want to consider farming that one out. And we all know from the Tort Claims Act that we can minimize our exposure and liability if we do that. If you anticipate that that's going to be a specific problem for you, you can avoid some legal risk by doing that. This is an old one. Be careful who you hire, and be careful when you fire. Anytime that you can carefully vet your hires, that's a great idea. I had a client recently that was hiring a person that unfortunately fell in like 3 discrete protected categories, and we didn't actually do that vetting process. And we were hiring this woman for the front office, and we'd already made the offer. And then I get the call that says, hey, we just found out that she's got 2 embezzlement convictions. What do we do? We're going to vet better in the future is what we're going to do. Fortunately, that one didn't turn out to be a problem, but it was quite illustrative of why we do vet, why we do want to know what we can find out about these people before we actually extend an offer. We talked a little bit about disciplining promptly and uniformly, but the bottom line of all of this is, in my experience with employment advice to clients and dealing with employment litigation, that bad employees never turn out to be good employees. It's just a slippery slope, and you are best to address those issues directly. Insurance. I know a little bit about that. Largely for a group like you, if you are a captive city attorney, this may not be a big issue for you, but we're not all in this room captive city attorneys. Some are part-time, some are independent contractors, some are, in and out. That does not mean that you won't also get sued as part of a solution, as part of a negotiation or situation that arises. That happens not all the time, but it certainly happens quite a bit. And I will tell you from my perspective in a former life that you each need to look at your personal malpractice coverage to make sure that you are covered, that if there's a situation where you get sued as a consequence of working with the city, that they will cover you as well. Frequently the answer is yes, but occasionally the answer is no. And for very little, you should make sure that you are personally covered. And the last point of this is probably a situation more for specific insurance coverage. And I have run into 2 political subdivisions this year so far that did not understand the difference between an occurrence policy and a claims made policy, and they were shopping for better rates, which we all should do. But what they had allowed to happen is they went from one claims made to the other claims made and didn't buy the tail coverage. And so obviously that's when the claim came in and they are without any coverage at all. And so we're looking at a rather expensive burden on the city to pay for the litigation costs. And of course it's a mess, and would have been a really good one for them to have had some insurance for, at least for the cost of indemnity. So if you are shopping for coverage, make sure you understand the type of coverage that you are buying, and make sure you understand the consequences of what happens when you change from one policy to the next policy, because it can be very, very harmful to the city. This kind of goes with some of the earlier claims. Look through your city. Where are you vulnerable? Stress test your departments, stress test your own office. Where are you likely to have problems? Where are your weaknesses? Look for those things. You can avoid litigation that way. And the last point is, it's not going to work because at some point we're all going to get sued. So what happens when we get sued? Well, we try to avoid it again in the future. And like Little Orphan Annie said, the sun will come out tomorrow. Even in the worst lawsuits, they'll be over, and then we will have a better day. But in the process, make sure that you've looked to find, why did this happen? Is it something that we can prevent? Was there a systemic shortcoming? Was there some sort of root cause? Was there a training issue? Was there some fact that came up that we can control in the future? So absolutely, anytime you have, whether it's the lowliest tort claim to a massive civil rights lawsuit, make sure that you take the time to draw everyone back in and do a postmortem.